Oh, hey, just pouring over these documents in this Drake lawsuit. Trying to figure out a couple things. Um, Everybody talking, but don't nobody know what they're talking about. So, I'm a former paralegal. We're going to figure out the basic legal principles that govern this case, where we are now, and what's next. And we're going to do all of that through the context of the UMG motion to dismiss, the Drake request for production of documents, the judge's order that followed that, and now the proposed case plan. So let's get into it. Like I said, I'm a former paralegal, and I've been watching like a million breakdowns on the internet. Drake just won, Kendrick just won, da da da. And it doesn't seem to me that anybody's talking about this through the proper framework. So let's go ahead and just dive in and get a little bit of clarity. And look, I know why you're here. You just want to know, are they going to get to see Kendrick Lamar's contracts? And I'll go ahead and tell you, no, they're not. So you can go ahead and leave. I even tell you why. They're not going to answer any sort of request related to a contract with anything but an objection. Relevance, attorney-client privilege, and unlikely to lead to any sort of admissible evidence. Then, after they're compelled by motion after motion, they're going to heavily redact everything because, again, most of that information within the contract is unlikely to lead to admissible evidence. So they're going to just take it out. They're going to remove it. But if you want to figure out why, stay tuned for the next, I don't know. You see the timeline. And we're going to start here with the motion to dismiss. Let me just take one moment to explain what a motion to dismiss is. I've already explained that UMG is presented a motion to dismiss. They filed this on March 17th. But let me explain what a motion to dismiss is. All right? A motion to dismiss is like when you're having an argument with someone. Let's say you're having an argument with your girl or your man, right? And they bring up this argument and you don't even have the time for it. And now let's say there's a third party who gets to decide if the argument will commence or it will cease. A motion to dismiss is like you turning to that third party and saying, hey, are we fucking for real, bro? Why are we even here? This is a waste of my time. I don't even want to do this argument. Here are the reasons we shouldn't even have this argument. I gotta go. And then the third party says, you're correct. This is a waste of everybody's time. And then you skedaddle and move on with your day. All right? That's what a motion to dismiss is. Basically, the party who didn't present the argument, right? The defendant party, they say, hey, I don't have time for this. This doesn't make any sense. Here are the reasons we shouldn't even have this argument. Let me know what you think. All right, so that's what a motion to dismiss is. Now, and I'm sorry, guys, all of the lawyers are busy. So that's why you got the young, hot, sexy paralegal with the fresh ass frames. And I do sit in my home just like this on a daily basis, breaking down legal documents. Let's get it. So we got the motion to dismiss from UMG, and it looks like they're gung-ho for this. It looks like they want all the smoke because the first paragraph lets you know, yeah, I want it all. That's why I strive for it. This me, you'll never hear a reply for it. They're going straight in like Drizzy, you cap from the get-go. You told us a long time ago you're not even with the disses, and here you are, the main guy instigating the whole situation. Plaintiff, one of the most successful recording artists of all time, lost a rap battle that he provoked and in which he willingly participated. This is going to be a key part of what they're talking about. Bro was willingly fully with the shit until it went, a different direction. Instead of accepting the loss like the unbothered rap artist that he often claims to be, he has sued his own record label in a misguided attempt to salve his wounds. Can somebody get that boy a Band-Aid? Look, Plaintiff's complaint is utterly without merit and should be dismissed with prejudice. That's what they got to say. So look, we starting off immediately with all the smoke. UMG's fully with this. They are not ducking. Drake ain't ducking. UMG ain't ducking. Everybody's got a big dick here. So the first thing I noticed about this motion to dismiss is I think UMG's been watching a lot of podcasts because we all talked about these same arguments. But Drake already told Kendrick to say it, and it's a diss battle. All right, guys. We're in a court of law now. Let's get some facts established. So, what UMG's trying to start off to establish is, look, guys, this is a context of a rap battle. That's the first thing, the most important thing. This is in the context of a rap battle. And that's going to become important later as to how they characterize the actual intention of the language used. Then they want to establish that Drake participated in this rap battle, and he had his own remarks that were less than complimentary of Mr. Lamar. So we're setting up this framework. This is a rap battle. Drake participated. Drake has been in numerous rap battles throughout the history of his career, and often he has utilized UMG to get his bars off. You see what I'm saying? So they want to go ahead and let the court know, hey, Drake did this before. We all are aware of what's going on here, and we all know the rules, the ethics, and the practices that occur within the rap battle. So that's how they spend the first part of this motion to dismiss. Just establishing, hey guys, this is rap. This isn't court of law stuff. We got to look at this a little differently than we normally do. But also, guys, this is a court of law. Rap fans, this is a court of law. So they look at things a little differently than we do. Everything's not so cut and dry. There are rules of procedure. So ultimately, what this first introductory part of the motion to dismiss is establishing is that Drake is a hypocrite, and he's simply doing this because he lost a rap battle. Now, is there credence to that? Of course there's credence to that. But let's look at the flip side of it. Because after that, so when we get through that first part of the motion to dismiss, as they establish this is a rap battle, Drake is fully with it. He's being somewhat hypocritical since he did participate in this rap battle and many others, and he has utilized UMG to promote those diss records. Let's actually consider what's being said. So in order to do that, we need to look at Drake's claim. Drake claims that he has been defamed, all right? Now, what this motion to dismiss states is Drake fails to state a claim for defamation. And let's see why they say that. What they do first is they lay out what you have to establish to achieve a successful claim of defamation. Now, the first part, you have to establish that a defamatory statement of and concerning the plaintiff occurred. Now, he called the boy a PDF file viewer. So that is a clear statement of defam. That's a clearly defamatory statement. There's no question about it. Yes, that is defaming of his character. Of course it is. Second part, publication to a third party. I saw this on the newspaper and the website and the application on my phone, and I saw it on the commercial on television. I saw it at the Super Bowl. Did they publish it to a third party? They did. No questions. Now, fault. That's where we start to get a legal question. Fault. Who is this the fault of? One question we have is this the fault of UMG? Is this the fault of Kendrick Lamar? That's a legal question to be answered. The courts will have to answer that question. Then we get into the falsity of the defamatory claim. Again, that's a legal question because is it false, the information that we received about Brother Man viewing PDFs of underage people? You know, I don't know, but so that's a legal question. Again, that can be uncovered by presenting facts, information, things of that nature. And what UMG has said is, we got that covered. We heard through the grapevine, through many different sources, that the boy definitely views that type of material. And we're not tripping by disseminating information related to that information. Okay? I said disseminating information related to that information. I know it. I know. Okay. You write it in the comments. He's an idiot. Okay. Next, we have to establish that there have been damages, monetary damages, reputational damages to Drake. And I don't know that that has occurred, but Drake could prove that. Let's say he lost $1 million here, 10 million there, 50 million there, 45 million there. That's damages. Let's say his homegirls don't want to hang out with him anymore because they think he's a bad dude. Alrighty. Let's say he's gotten numerous text messages from the baddies that say, I don't want to kick it with you anymore, Poppy. That's damages as well. So he could prove that. All right. So now, those are the rules of this claim. We got to establish defamation, the actual defaming statement. We have to establish that it did concern the plaintiff. We have to establish that that was published to a third party. We have to establish the fault, who did this. We have to establish the falsity of the defamatory claim, because if it's a defaming claim, but it's true, that's not defamation. And then we have to assess the damages. How much damage did you receive? If somebody said, that guy's ugly, and he's not ugly, but it didn't cost him any money or any reputational blowback, hey, what are we in court for? All right, so this is all of the stuff that matters here, guys. But now, bonus round, Drake is a public figure. So not only do we have to prove those things, but we have to prove this last thing, the standard of actual malice. Now, let me explain why this exists. What that states is the person who made the statement, because you are a public figure, they had to have actual intent to damage your reputation. This was established in a case called New York Times v. Sullivan, I believe mid-70s, some back in the day. And what this case wanted to establish is that if you are in a journalistic medium, right, you can report the statements that other people have made in order to inform your audience without having those statements held against you. That is going to be very important in this case, because as we know, Drake is the #1 rapper of all time, the biggest public figure to ever live. So that actual malice standard applies here. So UMG, Kendrick Lamar, whoever, had to actually intend to damage Drake. All right? And that's going to be difficult to prove. Okay? So that's why Drake wants all the contracts and all of the secret information and all of the, because he's got to uncover the lies. He's got to get deep in there and figure out the information that people are hiding from him because they don't want to see him lit. And UMG in this is saying, well, you can't find that. All right? So we gotta get this up out of here. We gotta get this shit up out of here. Now, in this motion to dismiss that UMG has presented, they have laid out those elements, and they say you can't stand up to those elements, right? Boom. Drake fails to state a claim for defamation. Right there, I saw it. Then they get down to the real nitty-gritty. And let me break this down for all the ladies, Okay? What this says is the alleged defamatory material is non-actionable opinion and rhetorical hyperbole. So basically what that means for all the laymen is he playing. Kendrick was playing, bruh. Kendrick was playing. He was being hyperbolic. Bro, this doesn't rise to the level of defamation because defamation has to involve facts and hyperbole is not fact. When you're engaging in hyperbole, you are aware that you are not saying fact. And when you are aware that you are not saying fact, you cannot be defaming someone. Whew, guys, it's getting too deep for the city. So after that, we go some more. We get into the to be defamatory, a publication must convey fact, not opinion or rhetorical hyperbole. That's what I just said, And so that's what they're saying for the next couple of pages. And then they get down here and they want to bring up some precedent. They want to say, hey, this is how the legal system has viewed this sort of interaction before. And here's an example. So recently there was a case called Michael Rappaport versus Barstool Sports. And what they said is their actor Michael Rappaport alleged his statements by Barstool Sports accusing him of having herpes and abusing his ex-girlfriend, including several statements in a 6-minute diss track in which defendants rapped a constant stream of insults and slurs about Rappaport against a backdrop of unflattering video clips and images were defamatory. So Michael Rappaport said, hey, you guys were doing a diss song on me publicly, and you showed pictures of me abusing my girlfriend, and you stated I had herpes, and that's defamation. What the court said is, unfortunately for Michael Rappaport, the Second Circuit affirmed the district court appropriately considered that the statements at issue were made in the context of hostile, vulgar, and a hyperbolic feud in which the use of epithets, vulgarities, and hyperbole function as a strong indicator to the reasonable reader that the statement is not expressing or implying any facts. Everybody knows you're playing, Kendrick, is what UMG said. We know this nigga playing, bro. He is not being serious whatsoever. And you could tell by the level of hyperbole, the level of slander, the level of slurs. Yeah, these guys are playing a game of the dozens. That's what anybody who was listening said, according to UMG. If you have a reasonable mind state and you went to elementary school or kindergarten, you noticed that these guys are not being serious. And if you were to leave this interaction stating, these were facts that I just witnessed, the issue is with you. So, moving past that, they said he's just playing, and they kept that up for a little while here. He's just playing. Likewise, the album image of Drake's Toronto house is obviously doctored, further underscoring the non-factual nature of Not Like Us. We all know that that was a fake picture and Kendrick was just playing. The broader context also reinforces that Not Like Us is non-actionable. Not Like Us did not emerge out of thin air. It was Lamar's culminating diss track in one of the nastiest lyrical warfare rap feuds in recent history. So again, this motion to dismiss is doubling down on, guys, context matters. This was a rap battle. We have to compartmentalize these statements and put them into the he's just playing box. Whew, they are going strong on that he's just playing. And then they get into some real spiel, right? Because earlier, I told you one of the elements is the falsity of ... right? The falsity of the claims. And so what they say right here, facts and criticism concerning Drake's relationship with minors predate Not Like Us and have widely been reported. Nigga, this tea is not even hot, is what they are saying. The tea isn't even hot. The tea is stale. Wow. So now they're stating, we don't even know if these claims are false because they've already been widely reported. So we're just, again, doubling down on our opportunity to report information that we heard, right? Finally, when we reach the end of the motion to dismiss, UMG is saying what they've intended to say this entire time. Please dismiss this case without prejudice. Without prejudice meaning it cannot be brought back up again. So what did UMG say in the motion to dismiss? Kendrick was playing. We knew he was playing. How do we know he was playing? He was in a rap battle. A rap battle is only people playing. And there you have it. We can't even move forward with this case according to UMG. But like I said, there's some real questions of legality. There are legal questions within there. The question of fault is a legal question. Who do you blame for this, Kendrick or UMG? That's a legal question. And the falsity of the statements, that's a legal question. So, is the motion to dismiss going to get, what's the word? So here you have it, folks. UMG is saying Kendrick did nothing wrong. We've done nothing wrong. We all knew he was just playing. How do we know he was just playing? He was in a rap battle where the only thing they do is play. It's not real. However, gotta be honest. Should this be denied based off of this motion to dismiss? Probably not. Because there are real legal questions to be answered. The question of fault needs to be answered. And the question of the falsity of the statements needs to be answered. And so what Drake's legal team did immediately, this was filed March 17th, before the judge could even consider the idea of whether this should be dismissed, is Drake's legal team said, we got these questions, and they filed them on March 18th. So that's like you being in an argument, right? You and your sis are in an argument, and your sis is telling mommy on you, and you're saying, hey, mom, we don't need to discuss this. And then your sister says, but wait, look at this. And your mom gets a glimpse of it, and she says, well, wait a minute, Chandler. I think based off of those questions on that paper, we actually do have to discuss it. So immediately following UMG filing their motion to dismiss and their brief in support, the very next day, Drake's legal team smartly went ahead and filed their request for production of documents. The goal being to make the judge see, hey, there are questions that we have that you'll be interested in. I think it was a smart move. Any lawyer I work with would probably suggest it. If they didn't suggest it to me, I would suggest it to them for the exact reason I just stated. Now, let's jump ahead a little bit. On April 2nd, the judge has denied the motion to dismiss. Boom. That means that they are going to have to respond to these requests for production of documents. Now, before I get into all of the excitement from all of the podcasters and bloggers, Drake gets to look through Lee Kendrick contracts, and Drake gets to go through.
So Drake just got a victory in court. That means that Drake and team, they can go in, they can look at contracts.
BBC that says the court gives Drake access to Kendrick's contracts, which is major. And this is a part of the discovery process.
But here's the big news on this today. Court gives Drake access to Kendrick's contracts.
Not able to get Kendrick's contract to UMG, his signing contract and his deals and all that. That sounds crazy.
Well,
one of the things he got was he got to take a little bit of an inside look into Kendrick Lamar's contract with UMG. All right, we're going to talk.
Let me explain something to you guys, dog. That's not necessarily the case. This is a win for you. This is a win for Drake's legal team. However, we got to break down the requests so you understand exactly what Drake's team is going to get to do and what they won't get to do. Now, looking through the requests, we got to start by breaking down the discovery process. Now, this is very important. Discovery has 4 elements: interrogatories, request for production of documents, request for admissions, and the deposition phase. Now, each one of these are a little bit different. Interrogatories are questions that you have that you need answered. So basically, an interrogatory might be listed as such. Name all the people that work with Kendrick Lamar. Name all of the people that work with Kendrick Lamar. Now, request for production of documents involves an actual document to prove that interrogatory. For example, provide the timesheets for the employees that work with Kendrick Lamar. Make sense? Not only do you have to list their name, but you have to provide actual documentation that proves what you stated. Then you have the request for admissions, and those require the defendant party to admit certain information. As you can imagine, most of the time those admissions are denied. Example, admit that Lucian Grange worked with Kendrick Lamar. And of course, you would deny something like that. So now that you know a bit about the discovery process and how it works, let me go ahead and tell you about the deposition process. The deposition process basically entails all of those things, but you actually get to sit in front of a witness and verbally depose them or question them on that same information. So that's where the request for production of documents comes in. I've already told you that they went ahead and smartly put that request in the next day after the motion to dismiss. And I've also already told you that motion to dismiss has been denied. So now UMG is going to have to respond to this request for production of documents. So let's see what they're asking for. What do they want? They want all contracts and agreements between you and Kendrick Lamar Duckworth and his agents or anyone working on his behalf, including all contracts and agreements reflecting your right to approve, reject, refuse, publish, edit, amend, alter, or veto the publication of Kendrick Lamar Duckworth's musical works, videos, or other content. They're being all inclusive in there. So they want all of his contracts. Here's the part that those other media outlets didn't tell you. In law, you get to object to certain things. Most of the times your objections are based on relevance, privilege, a privileged communication between an attorney and a client, or the request being unduly burdensome, meaning that the request is so large that the amount of effort that it takes to provide that information to you outweighs the value of actually providing it to you. So let's say I told you to provide me every contract that UMG has ever written with anybody. That would require 100 years of contracts to be turned over. That's way too much, right? And it's not likely to lead, most of that information is not likely to lead to anything reasonable. So in those circumstances, you don't have to return over that information. You get to go ahead and put your objection and move on. So let me explain to you what's going to happen, because this seems to be the only request that anybody cares about, Kendrick Lamar's contract. They're not going to turn that over. They're going to put an objection based off of relevance, right? They're going to put an objection based off of unduly burdensome, not likely to lead to admissible evidence. And then they're probably going to throw in the objection based off of attorney-client privilege, because that contract was drafted with an attorney, likely who works for Universal Music Group, who has a relationship. And they're not going to provide that information. Sorry to spoil it for you guys. For anybody saying, but that's not fair, Drake didn't get a fair shot, but he asked a question and he doesn't get... Look, what Drake's team is going to do at that point, they're going to put out a motion to compel this information, right? And then the court's going to get to decide at that point. So we're not really at the juncture yet where we'll actually get to see whether or not Kendrick Lamar has to turn over his contracts. With that being said, there will be a motion to dismiss hearing. I believe it's June 30th at this point, and that's the day we'll determine if this case will continue to move forward or if this case will stop right in its tracks, right? As we saw yesterday, the court ordered them to do a case management, and on that schedule, they had to answer several questions, And one of the questions was, have you all discussed the settlement? And the answer was no.
Drake is reportedly getting offered a $250 million settlement lawsuit.
So the reports that they $250 million settlement, that's false. There has been no discussion of a settlement. And I'm willing to bet that outside of writing down the objections that they have to these requests, UMG won't be doing very much at all in relation to this case between now and June 30th. So everybody who was so happy that Drake legal team gets to see Kendrick's contract, and all of the really curious cats who wanted to see Kendrick's contract themselves, I think you're going to have to wait. And ultimately, I do think this case will be dismissed, and for the sake of us all, I hope it's dismissed. Here's the one thing I haven't heard anyone speak on. In the discovery process, the defendant also gets to ask for records related to claims that they've made, or maybe remarks that they may be defending. So nobody has commented on the fact that UMG is going to get to ask for records of their very own. Maybe they'll ask for Instagram conversations, DMs. Maybe they'll ask for phone records. Maybe they'll ask for text message histories. Who knows what they'll ask for? And when they ask for that shit, maybe it'll be overwhelming. You know what I mean? Unduly burdensome. So who should provide their whole DM history? So maybe UMG will have to narrow the search history down to specific individuals that they may think they're aware of that have had weird interactions. If they already know about those people's weird interactions, maybe they already have their own records from those individuals. Whatever the case, I don't think this case will go on too much longer. Because that would be detrimental, no matter what. So, but the attorneys have probably already informed my man, so I don't know. Everything must be hunky-dory, you know what I mean? So we're going to keep going. We're going to keep moving forward in this case. This has been some terrific fun for me because I get to involve my two passions, hip-hop and law analysis. And so thanks for stopping by. Thanks for tuning in. Like, share, subscribe. And yeah, put your comment. Tell me what you think. If I'm totally wrong, put it down below. Because I'm probably, hey, I could be totally wrong. So tell me below what you think. And tell me what else you want me to talk about.